This is Justice Done Dirt Cheap. It's July 17, 2012. We're at the Canadian Legion. Just want to share some thoughts with you all regarding the Canadian legal system and specifically the experience that I'm having in New Brunswick. I've been dragged into provincial court regarding some what I believe are frivolous, vexatious, and abusive process allegations that have turned into criminal charges against me. And what's really amazing is that when one starts looking at the documentation that is presented to the court and filed, it's a very simple process regarding the Criminal Code of Canada. And the Criminal Code of Canada is something that has devastating effects on people's lives. To have charges laid against you that are without merit, and then to have to defend them, because if you don't defend them, you'll basically be found guilty. So one has to defend themselves from criminal charges to basically stay out of jail and to remain free. Not only that, there's the consequences of if one's found guilty of crimes and there's a criminal record that's established that can be a detriment for trying to seek gainful employment, and it can have a very negative impact on people's families, their jobs, their occupation, things like that. Now, what I've been experiencing, this is the first time I've been through the criminal procedure process, and what I've been experiencing is that, okay, before I do that, I'll just give a basic explanation of how it works. How the Criminal Code of Canada is set up is that if someone is accused of a crime according to the Criminal Code of Canada, the police decide to lay in information. And information is a basic document that just gives the substance of the crime, bare minimum of facts, and that information is the document that engages the court criminal process. Now, from the time the information is laid, that is provided to the Crown. The Crown has an opportunity to review the information, and there's two tests that the Crown are supposed to conduct. One is called the evidence test, and the second is called the public interest test. And the evidence test is basically if there's enough evidence to substantiate the claims, then that test has been passed and they move on to the next part of the test. If there's not enough evidence to substantiate the claims, then at that point the Crown should just drop the charges and not pursue with public resources a criminal charge against someone without evidence against them. This is a safeguard to keep people from being in jeopardy who have no evidence whatsoever against them to support an unfounded allegation of criminal conduct. Now, if this mechanism is operating correctly, if there's, at the point of no evidence, the Crown should drop the matter, and if someone really wants to pursue it, a private individual can pursue a private prosecution, which means they have to pay for it themselves. And this allows for people to pursue matters that are not in the public interest to pursue. Now, what's interesting is the second test that the Crown Prosecutor's Office is supposed to do. It's called a public interest test, and they need to decide whether it's in the interest of the public, as in, should they spend the public's money and time and tie up the judicial resources to pursue a criminal matter that either is not likely to succeed based on the circumstances, as in, does the person who is being charged have a history of a criminal record history, or have they been charged with the same offense multiple times, or are the circumstances so egregious or bad that something needs to be done? And if so, then then the Crown Prosecutor has taken that information and put it to the test of the evidence test, then the public interest test. And if it's passed both, then they move on to actually prosecute the charge. Now, what's interesting is that the charges in the Criminal Code of Canada, there's 3 types of charges. People may not realize this. There's indictable, which are the most serious offenses. There's only about 20 of them in the whole Criminal Code of Canada, and the Criminal Code is pretty big, but only 20 charges are actually serious enough to be solely indictable. Many of the charges are called hybrid offenses, which means the Crown can elect to pursue the matter on a indictable offense or on summary conviction. And then the third type is called summary conviction. Summary conviction are the lesser crimes, the things that are not substantial. They have a lesser monetary fine and a lesser sentence. As an example, if a particular crime if a particular crime is a hybrid offense, if the Crown pursues an indictable version of that, then the person accused of it could be facing 2 to 5 years in jail if successful on conviction, as in if the Crown is successful convicting that person. Now, on the other hand, if the Crown elected to pursue the matter through summary conviction, there might be a maximum of 6 months in jail and maybe a $500 fine. There's quite a difference between the two. So depending on the circumstances, the same crime, depending on how, the overall circumstances, the Crown can go one way or the other, and there's a big difference between the two. And what's interesting is the Crown's handbook, like the prosecution manual, states that for the most part the Crown should be electing to go with summary conviction offenses unless the circumstances are substantial enough to warrant, to justify pursuing a indictable offense, because that's a serious loss of liberty to an individual to be facing a 5-year jail term instead of a 6-month jail term. Also, if you're spending over 2 years in jail, you're going to a federal incarceration unit, whereas if it's less than 2 years, you're going to a provincial incarceration unit. So, just to give you that information on the technical side of the criminal procedure, which is quite interesting to learn, the other thing that I've seen is, on a personal matter, I keep seeing that the Crown Prosecution Office, the police, and the courts are not actually adhering to the Criminal Code of Canada. Now, the Criminal Code of Canada was established to limit the ability of the state to take away our personal freedoms. Now, if the police, the Crown Prosecutor's Office, and the courts were actually adhering to the Criminal Code of Canada, there's some pretty good safeguards in the Criminal Code of Canada to stop arbitrary detention and arbitrary arrest and people being prosecuted on matters that they should not be. But unfortunately, the experience that I've had so far is the police are not doing their job correctly, the Crown Prosecutors are not doing their job correctly, and the courts are not doing their job correctly, because if they were, I would not be facing these criminal charges in the way that I am. In my own personal experience and my own experience so far in the courts and reviewing the documents, I keep seeing that the police do not fill out the correct documents, they're acting inappropriately. The Crown should be dropping these charges themselves, just motioning for a stay of proceedings, because there's no grounds to justify using up public money and judicial resources to pursue these charges. Just on their face, they're meritless. So maybe other people have had different experiences, but in my experiences so far, it's been negative. And if the police, the courts, and the Crown Prosecutors are operating correctly, then there would be a limited amount of infractions on our personal freedoms. But unfortunately, because the police, the Crown, and the courts are not operating according to the wording and the law, the Criminal Court of Canada, there's many more people who are having negative experiences than should be. The courts are full of individuals who have stories just like mine. When you begin talking to people who are in court, you find out that there's flawed procedure here, flawed procedure there, incorrect paperwork, and unfortunately even the lawyers that represent parties against the Crown, as in defense lawyers, seem to sweep that information under the rug. They don't pursue it, and because they're all Law Society members, they're actually bound by an oath to the Law Society to not pick out each other's faults and to not basically attack the proceedings. I'll have to provide a video and some future date regarding the Law Society Act in New Brunswick and the actual duty the Law Society has to each other. You got to think the defense lawyers, the Crown Prosecutors, and all these different lawyers who are all appearing in court are all part of the same Law Society. In New Brunswick, you have to be a member of the Law Society to practice law. So, just on that thought, thank you for listening. It's July 17, 2012. It's Justice Done Dirt Cheap. Have a great day.